Good day to all. I celebrate today the opportunity which was given to me 50 years ago on this date and at this time, on the 17th of April, 1975, to fight the legal battles I fought for the independence and fearlessness of lawyers in discharging their duties to their clients, who they represent before the courts, and also in discharging their duties to the court. On that date, at this time, I accused Justice Sonny Maharaj at the San Fernando High Court of unjudicial conduct whilst I was appearing before him at the San Fernando High Court because of decisions he made to dismiss my client's cases and defense of a client without giving them an opportunity to prove their claims and one of my client's defense. The judge charged me and summarily convicted me for contempt of court because I accused him of unjudicial conduct, and he sentenced me to 7 days simple imprisonment. There was no right of appeal in Trinidad and Tobago at the time for me to appeal that decision to the Court of Appeal. Notwithstanding there was no right of appeal, Dr. Fenton Ramshaw, his senior counsel on my behalf, later that day, filed a claim pursuant to the provisions of the Constitution of Trinidad and Tobago, in which he claimed on my behalf that the judge in charging me and convicting me for contempt of court contravened my fundamental rights guaranteed in the Constitution of Trinidad and Tobago, and that the order of the judge was unconstitutional. My claim was based on the Constitution that I was guaranteed in Section 1 of the 1962 Constitution of Trinidad and Tobago the right to liberty and the right not to be deprived thereof except by due process of law. The contention of my claim was that I was imprisoned by the judge without the judge observing due process of law to make his decision to charge me, to commit me to prison. Dr. Ramshaw, having filed that claim under the Constitution on the afternoon of the 17th of April, 1975, made an application to the High Court in order for me to get bail pending the hearing and determination of that claim. Justice Johnny Brathwaite of the High Court granted me bail that evening and ordered my release on bail, and for the constitutional claim to be heard by the High Court on the 23rd of April, 1975. The Chief Justice, Sir Isaac Hayatali, decided that Justice Garvin Scott instead would hear the claim. The judge heard the claim, and having considered all the evidence, the judge and the submissions of the lawyers, the judge decided to dismiss my claim. He also decided to refuse my application for bail pending my appeal to the Court of Appeal against his decision. An application was made to the Court of Appeal for me to be granted bail pending the hearing and determination of my appeal before the Court of Appeal. But that appeal was also refused that application was also refused by the Court of Appeal. Although there was no right of appeal to the Court of Appeal in respect of a conviction for contempt of court, I decided to file an application to the Privy Council for special leave to appeal to the Privy Council to hear my appeal against the conviction of contempt. While my appeal against Justice Garvin Scott was pending in the Court of Appeal, I had to serve this term of simple imprisonment at the Port of Spain jail. My wife, Lynette Maharaj, a brilliant attorney at law, saw me every day in the prison. I made it clear to the Commissioner of Prisons that as a contempt prisoner, I was entitled to see my lawyer privately, and therefore I saw my wife privately at the prisons. Every day after my wife visited me at the prison, She addressed the crowds outside the prison and told them that, among other things, that I was determined to pursue the fight for the independence of lawyers to the highest court, even if it meant taking the appeal to the Judicial Committee of the Privy Council. She told them that it was important for lawyers to be independent and fearless in doing their duties before the courts. Otherwise, the rights of individuals in Trinidad and Tobago would not be properly protected. She addressed them on the importance of lawyers and told them that if lawyers were not independent and judges were not independent in doing their duties, the profession in Trinidad and Tobago, the legal profession, would be sycophantic and subservient, and the rule of law would be jeopardized in the country. In 1965, I went to study law in England. At that time, I was 19 years of age. I joined the Inner Temple, which was one of the institutions that one had to study law. In those days, it was possible for students to work hard and complete the law exams in 18 months. I did that. At the age of 20 years, I passed the law exams and could not be called to the bar, because in order to be called to the bar in those days, one had to be 21 years of age. I had to wait until November 1966 to become a lawyer. I spent time in London in chambers doing my pupillage and returned to Trinidad in 1967 when I was admitted to practice law. In April 1975, when I was imprisoned by the judge for contempt, I had twin daughters who were just 2 years old. Sushma and Kavita were my twin daughters, and my son, Ramesh Jr., was born in January 1975. My wife, Lynette, was also a practicing lawyer with me, and I must confess it was difficult. It was a difficult period of my law practice to have to fight these legal battles. In fighting these legal battles over the years, it has not been easy. It has been difficult, but I consider myself privileged and to have been honored to have the opportunity to fight these legal battles. Before I give you more of the importance of these legal battles, I want to pay special tribute to my wife, Lynette Indrani Maharaj, Senior Counsel, without whom it would not have been possible for me to have fought these battles. She understood the importance of fighting these legal battles and knew that without fighting them, the independence of lawyers and judges would have been compromised in Trinidad and Tobago. I would also like to thank my children who understood the battles I was fighting. I know they were very young at the age when I was fighting the battles in 1975, but as they grew up, they understood the battles which I fought. In April 1975, I was successful in having provisions of acts of parliament declared unconstitutional by the courts. This was the first time in Trinidad and Tobago that any provision of an act of parliament was declared unconstitutional by the courts. I was successful in having the Unemployed Levy Act declared unconstitutional by the High Court. That decision was subsequently reversed by the Court of Appeal. I was successful in having provisions of the Cess Act declared unconstitutional. That act compelled cane farmers to pay to Carney Limited sums of monies which were for the benefit of the Trinidad Island-wide Cane Farmers Association. Notwithstanding, they did not agree to be members of that association. The monies were compulsory deducted for them to join that association. That offended the right to freedom of association and the right to the enjoyment of property. I was successful in having those provisions of that act declared unconstitutional. It was during that period of time and during the time that the Court of Appeal was hearing the appeal in that matter, that I had matters before Justice Sonny Maharaj in San Fernando. And in respect of those matters, he unjudicially dismissed those matters, did not give the clients an opportunity for them to have their cases conducted in the normal manner, and therefore I accuse him of unjudicial conduct. He considered that to be contempt of court, and he imprisoned me for 7 days. There was no right of appeal in Trinidad at the time for me to appeal to the Court of Appeal against that contempt decision. I then I filed a special application to be granted special leave to the Privy Council for the Privy Council to hear that appeal. In the meantime, Dr. Ramsahoi filed this constitutional motion before the High Court for me to be granted relief. The High Court judge did not grant me bail, and the matter was appealed to the Court of Appeal. At the Court of Appeal, the Court of Appeal, in a majority decision, agreed with Justice Garvin Scott that my constitutional right was not infringed and that I had committed a contempt of court as decided by Justice Sonny Maharaj. I appealed that decision to the Judicial Committee of the Privy Council, and the Judicial Committee of the Privy Council decided that the Court of Appeal was wrong and Justice of Appeal Clements was right. Lord Diplock and 3 other judges of the Privy Council disagreed with the decision of the Court of Appeal and affirmed the decision of Justice of Appeal Clement Phillips. One of the judges of the Privy Council, Lord Hilsham, dissented and gave a minority the decision. That decision of the Privy Council is reported in 1978, 2 All England reports at page 670. Lord Diplock held that the order made by Justice Sonny Maharaj amounted to a contravention by the state of my guaranteed constitutional right to the right to liberty guaranteed in Section 1A of the Constitution. The Privy Council affirmed the order of Justice of Appeal Clement Phillips for me to receive compensation from the state for my imprisonment. That decision of the Judicial Committee of the Privy Council was important because it was the first time in the Commonwealth it was held that when a judge violated the Constitution, the state was liable. The judge was immune from liability, but it was held that the judicial arm of the state was liable and that the Attorney General representing the state had to pay the requisite compensation for damages. In the meantime, the Judicial Committee of the Privy Council heard a contempt appeal against a conviction, and the Privy Council, in a unanimous decision given by Lord Salmon, set aside the conviction for contempt, and it ordered the state to pay the costs of the appeal. That decision of the Privy Council is reported in 1977, 1 All England report at page 411. This case attracted the attention of persons in the Commonwealth, and Marcel Berlins, the legal correspondent of the London Times, came to Trinidad to interview me because he stated he was writing a book on the legal battles which I fought for the independence of lawyers in the Commonwealth. He wrote the book Barrister Behind Bars, which was published by Key Caribbean Publications. The book documented a full account of the legal battles I fought to promote and to safeguard the independence of lawyers in the discharge of their duties. Marcel Berlins, in that book, Barrister Behind Bars, stated from his research, I was the first barrister at law in the English-speaking world since 1607 to be imprisoned by a court while arguing a client's case before the court. Let me tell you something about the unjudicial conduct of Justice Sunny Maharaj. Lord Salmon, in giving the judgment of the Privy Council in the contempt appeal, stated at page 415H, and I quote, "Unjudicial conduct covers a very wide spectrum from instances in which the judge has asked far too many questions, or by excess of zeal for speedily disposing of his list has prevented one side or the other, or both, from properly presenting their case, to instances in which a judge has acted dishonestly or corruptly." Lord Salmon at page 415J at 416A decided that the summary power of a judge to charge and to punish for contempt should be used sparingly and only in serious cases. His Lordship stated that it is a power which a court must possess of necessity, but stress its usefulness, however, depends on the wisdom and restraint on which it is exercised by a court. His Lordship stated that contempt of court punishment must never be used to suppress methods of advocacy of lawyers which are merely offensive, because that would be to use it for a purpose for which it was never intended. During the period of time I spent studying law in England, I read a lot about the importance of the independence of judges. I was impressed with the words of Sir Thomas Erskine, who spoke on the independence of lawyers, and he was regarded as one of the eminent lawyers in the 17th century. And he said these famous words about the duty of lawyers, and I quote, "I will forever, at all hazards, assert the dignity, independence, and integrity of the English bar, without which impartial justice, the most valuable part of the English Constitution, can have no existence." I continue in quote, "From the moment that any advocate can be permitted to say that he will or will not stand between the Crown and the subject arraigned in the court where he daily sits to practice, from that moment the liberties of England are at an end." End of quote. In 1990, the International Bar Association adopted Article 6 of the Standards for the Independence of the Legal Profession. It states, and I quote, "Subject to the established rules, standards, and ethics of the profession, the lawyer in discharging his or her duties shall at all times act freely, diligently, and fearlessly in accordance with the legitimate interests of the client, and without any inhibition or pressure from the authorities or the public." End of quote. I also feel privileged to celebrate today the opportunity that was given to me recently by the Judicial and Legal Service Commission on the 27th of April 2017 to fight the legal battles which I fought to defend the independence of the judiciary and the security of tenure of judges. When the JLSC decided to force the Honorable Madam Justice Maharaj S.C, hereinafter I refer to as a judge, to resign her office as a judge. Both the Court of Appeal and the Judicial Committee of the Privy Council decided that the JLSC, by its decision made on the 27th of April 2017, intended to threaten, coerce, and pressure the judge to resign from office, and that decision of the JLSC was contrary to the provisions of Section 137(3) of the Constitution. The Privy Council held that the conduct of the JLSC in threatening and forcing the judge to resign was illegal, and that the judge continued to remain a puisne judge of the Supreme Court of Trinidad and Tobago because her purported letter of resignation was procured by the illegal conduct of the JLSC and was consequently null and void and of no effect. That legal battle started in 2017 concluded in 2025, lasted 8 years. Section 1373 of the Constitution provides a specific method and procedure to remove a judge from office. The JLSC decided not to use that method stated in the Constitution to remove the judge. It instead decided to act illegally and to use threats to force the judge to resign. The threats which the JLSC used to force the judge to resign included false media releases, one signed by the judge and one signed by the Chief Justice, to give the false impression to the public that the judge voluntarily resigned, when in truth and in fact it was known to the JLSC in those two press releases which were issued to the public on the 27th of April 2017, to give the impression to the public that the judge voluntarily resigned, when in truth and in fact she was forced to resign. Both the Court of Appeal and the Privy Council agreed that the JLSC forced the judge to resign, contrary to Section 137 of the Constitution. The people of Trinidad and Tobago must understand, and the media must also understand, that the rule of law cannot be enjoyed in Trinidad and Tobago by the public unless there is an independent and fearless legal profession to represent persons before the courts. Lawyers must not be intimidated or harassed to prevent them from doing their duties to their clients and to the courts. They must be able to present their cases fearlessly and without threats or intimidations. If lawyers are not free to represent their clients fearlessly, unintimidated, and not harassed, the legal profession in Trinidad and Tobago would be sycophantic and subservient, and the rights of the public would be compromised. Similarly, judges of the Supreme Court must be independent, and they must enjoy security of tenure. Those basic principles are guaranteed in Section 137 of the Constitution of Trinidad and Tobago. The Constitution prohibits the JLSC or any individual or authority in Trinidad and Tobago to force or threaten a judge to resign. Judges must not be threatened or forced to resign, either by the executive arm, legislative arm, or judicial arm of the state. No service commission is above the law to threaten and force a judge to resign. It is my hope that by the legal battles which have been fought, that lawyers, the Law Association of Trinidad and Tobago, the Assembly of Southern Lawyers, and all other groups of lawyers in the country would always take proactive and aggressive steps to protect and defend the independence of the judiciary, the security of tenure of judges, and the independence and fearless discharge of the responsibilities of lawyers. There must be no compromise on these basic principles. If these principles are compromised by the legal profession, the rule of law in Trinidad and Tobago would be compromised, and the rights guaranteed in the Constitution would also be compromised. I have been in practice of law in Trinidad and Tobago for over 50 years. I enjoy these battles I fought over the years to develop the law of Trinidad and Tobago, both as a lawyer in private practice and as the Attorney General of Trinidad and Tobago. Notwithstanding my age and that I have practiced law for approximately 57 years, I feel very energized to take on more legal battles, especially where those legal battles involve the independence of the legal profession and the independence of judges, their security of tenure, and the infringements of constitutional and public law rights. I believe in the principle that law must not only speak justice, but it must also deliver justice. Thank you very much.